They built 100 homes on my floodplain without ever buying the land. The developer claimed a 1962 deed gave him title to the back 400 acres of my Brown County property. The deed was fraudulent. The permits were forged. The foundations were slab on grade on land my great-great-grandfather had warned the county would flood in 1838. Her name was Tabitha Ashland Cromwell, HOA board president of Hayland Crossing Estates, Indiana, 48, polished, blonde, presiding over a phantom community built on the wrong man's land. Mine is Octavius Brookmeer. I am a retired Indiana University industrial historian. The week the Indiana DNR issued me a permit for routine dam safety release, I opened the 1838 sluice gate on Brookmeer Lake. By dawn, 93 of the 100 frames were collapsed in the mud. What would you do if a stranger built 100 houses on your great-great-grandfather's land? Where are you watching from tonight? Stay with me. My great-great-grandfather Cornelius Brookmeer received the original federal land patent for 850 acres in what is now Brown County, Indiana, on the 11th of June, 1838. He had walked west from Lancaster County, Pennsylvania, with his wife Aldina and 4 children the previous spring, following a Quaker survey expedition that had identified the southern Indiana hill country as undervalued by the Federal Land Office. He paid the Federal General Land Office $1.25 per acre, the standard preemption rate under the 1820 Land Act, for a total of $1,062.50, paid in U.S. silver coin Aldina had sewn into the lining of her winter coat. The original parchment patent, signed in Washington by the Commissioner of the General Land Office, hangs in a climate-controlled archival case in the front hall of the original 1839 Brookmeer farmhouse. The patent is one of 3 surviving federal land patents in Brown County from before the state's 1840s land rush. The other 2 hang in the Brown County Historical Museum. Cornelius built the original mill in the spring and summer of 1839. He had been trained as a millwright by his uncle in Reading, Pennsylvania, and had brought west with him a complete set of 19th-century millwright's tools, plans for a 15-foot overshot water wheel, and a particular ambition to build the first commercial grist mill in the upper White River drainage. He surveyed the back acres of his patent and identified a narrow valley where a small tributary of what would later be called Salt Creek ran between 2 limestone shoulders. He built a stone and earth dam across the valley at the narrowest point, 68 feet across at the crest, 44 feet high at the maximum spillway elevation. He set the dam's wooden sluice gate himself in October of 1839, using white oak from his own back 40. The dam impounded what was, by his original surveyor's mark, a 38-acre lake. The lake powered the overshot water wheel through a stone race he chiseled across 9 months of 1840. The mill ground its first wheat in March of 1841. The mill operated commercially from 1841 to 1928. The mill stopped grinding in the Depression. The mill stood idle from 1929 to 1987. I was born in the original 1839 farmhouse in November of 1954. My grandfather, Hollis Brookmeer, had inherited the property from his father in 1932 and ran the family farm, corn, dairy, and a small heritage apple orchard for the next 40 years. My father, Ansel Brookmeer, took over from him in 1972. My father died of a stroke in the upper field in August of 1987. I was 33. I had just made associate professor of history at Indiana University in Bloomington. I had been on track for a long career as a specialist in early American industrial history. The Brown County farm had been, until my father's stroke, a place I visited on weekends to walk the back 40 with him and listen to him talk about Cornelius and the mill. After the stroke, the farm became mine. The mill, idle for 58 years, became mine too. I spent the next 37 years restoring it. The restoration was, in plain academic terms, the single longest active research project of my career. I documented the original 1839 construction methods. I located the original blueprints in the Indiana State Library archives. I located the original water wheel components in a Bloomington antique tool barn, where they had been quietly stored since 1932. I rebuilt the water wheel myself across the summers of 1991 through 1996, with help from a Brown County millwright named Bertram Crow and 3 graduate students who took my industrial history seminar that decade. The water wheel turned for the first time in 69 years on the 21st of March, 1997, the spring equinox, the day Bertram had told me my grandfather Hollis would have set the wheel turning if he had ever rebuilt it himself. The wheel has turned every spring equinox since. The mill ground its first wheat in over a century on the 21st of March, 2003, the year I retired from full-time teaching at Indiana University after 26 years. My first wife, Wren Brookmeer, Wren Halloran then, passed of breast cancer in November of 2007. We had been married since 1979. We had one daughter, Margot, who is now 41 and a professor of American Studies at Purdue. After Wren's passing, I had not expected to remarry. I had been wrong about that. I met Phoebe Vandermeer in 2010 at a small symposium on Indiana industrial heritage hosted by the Indianapolis Museum of Art. She had been the museum's curator of decorative arts. She had been widowed in 2009. Her husband had been an Indiana University philosophy professor who had been my friend for 15 years. We had known each other peripherally for 2 decades through the small academic society of Bloomington intellectuals. We had not known each other as people who might marry. We were married in October of 2012 at the mill. Phoebe is now 63. She retired from the museum in 2018. She has one son, Caspian Vandermeer, who is 38 and an environmental attorney in Bloomington. Yes, the same first name as the New Hampshire Drummond daughter Saoirse's debate trophy from the Master Key case. Just a coincidence of vintage names. Phoebe and Caspian became my family alongside Margot in 2012. The 4 of us spent every summer through 2023 at the mill. The 850 acres are recorded in the Brown County Recorder of Deeds office under instrument number 1838-014-A, with continuous ownership in the Brookmeer family across 5 generations and 186 years. The original patent is on file. The chain of title is unbroken. No portion of the original 850 acres has ever been legally transferred out of the family. There was one small attempted transfer in 1962. My grandfather Hollis had received an unsolicited cash offer of $43,000 from a Bloomington real estate speculator named Knox Hayland for the back 400 acres along the South Fork of Salt Creek. Hollis had received the offer on a Friday in March. He had thrown the offer in the wood stove on a Saturday morning. He had told my father, who had told me 30 years later when he was teaching me the property records, that Knox Hayland had been the kind of man Cornelius Brookmeer had walked west from Pennsylvania to get away from. The $43,000 offer was returned to Knox Hayland by certified mail on the 23rd of March, 1962. My grandfather had attached a single handwritten sentence. Mr. Hayland, this land was paid for in silver. Aldina Brookmeer sewed into a coat in 1837. It is not for sale to you or your descendants in any year of this century. Hollis Brookmeer. I had not, before the spring of 2024, considered Knox Hayland's grandson, Lex Hayland. Yes, the same first name as the Master Key case husband, Lex Bartholomew. Again, a coincidence of vintage names. To be a relevant figure in my life, or in the property records. I had not, before the spring of 2024, ever heard the name Hayland Crossing Estates. I had not, before the spring of 2024, walked the back 400 acres in approximately 18 months. The back 400 sit on the far side of the dam impoundment, accessible only by a fire road I maintain twice a year, and I had been busy with the mill's interpretive program for visiting school groups. The back 400 had been quiet. The back 400 had been, for 2 centuries, undisturbed Indiana hardwood forest, with a small floodplain along the South Fork of Salt Creek, until they were not. The restoration project itself, from 1987 forward, taught me my own land more thoroughly than any university course had taught me anyone else's history. I had walked every acre of the back 40 in detail across the first 10 summers of the project. I had mapped the historic mill race by hand. I had surveyed the floodplain channel with my graduate students using 19th century survey methods I had reconstructed from Cornelius's own journals. I had identified, by 2005, every original 1838 corner monument my great-great-grandfather had set. 6 of the 8 original monuments still stand in place, 2.5 feet of native sandstone, hand-chiseled with the letters CB and the year. The 7th monument had been removed during a 1957 county survey error and was relocated in 1962. The eighth monument I located in 2008, buried under 19 inches of accumulated leaf duff at the southwest corner of the original patent. Still in its original setting, still legible, still upright after 170 years. I documented all 8 in a peer-reviewed article in the Indiana Historical Bureau Quarterly in 2009. The article remains, as of this writing, the most complete survey of an 1838-era federal land patent corner monument system in the state of Indiana. I had not, in 2009, expected the article to ever matter as more than academic record. The article would later be filed as an exhibit in the federal title fraud case. I learned about Hayland Crossing Estates by accident on a Wednesday afternoon in late April of 2024. Margot had driven down from West Lafayette to spend 2 days at the mill, helping me reorganize the Industrial History Archive in preparation for a fall exhibit. We had been at the front porch with our laptops after lunch. She had been searching the Indiana State Property Database for a tax record on a Bloomington dissertation she was supervising. She had typed Brown County Hayland into the database search field by mistake. She had meant to type Hayland Court, the dissertation's subject property. The search had returned, instead of the Bloomington property she expected, 14 results from Brown County, dated between 2021 and 2024. All 14 results involved a corporate entity called Hayland Crossing Estates, LLC. The corporate entity had filed 31 separate construction permits on a project described, in the database records, as Hayland Crossing Estates Phase 1, 100 residential units on 400 acres at Salt Creek South Fork, Brown County, Parcel 17-09-04-300. Parcel 17-09-04-300 is my parcel. Or rather, Parcel 17-09-04-300 is the back 400 acres of my parcel. The same back 400 my grandfather Hollis had refused to sell to Knox Hayland in 1962. The parcel is recorded continuously in my family's name since 1838. The parcel had not been transferred to any party since the original 1838 federal patent. The corporate entity, Hayland Crossing Estates LLC, had no claim to the parcel and no entry in the chain of title. Margot looked at me. I looked at her. She said, "Dad, open the construction permit records. Show me what they have been building." I opened the permit records. The records included site plans, foundation specs, framing schedules, and contractor invoices. 100 residential units, 54 units already framed and dry in, 46 in earlier stages of construction. Total project value, by the developer's own filing, $48 million. Estimated completion date for Phase 1, November of 2024. The site plans included satellite images of the construction footprint. The construction footprint covered approximately 180 acres of the back 400. The footprint sat directly in the South Fork floodplain. I stood up from the porch. I walked to the front hall. I took the original 1838 federal land patent down from its archival case. I carried the patent back to the porch. I laid the patent on the porch table next to Margot's laptop. I said, "Margot, they are building 100 houses on Cornelius Brookmeer's grant, without any of my paperwork, without any of my permission, without ever having walked across my dam to ask if I knew." Margot read the patent. Margot read the permits. Margot read the LLC filings. Margot's research training kicked in the way it kicked in when she found a primary source nobody had read before. She pulled the Brown County Recorder's database open on her laptop and walked through every record on Parcel 17-09-04-300, going back to 1838. She found the patent. She found the unbroken chain of inheritance through Cornelius's son Eli, Eli's son Hollis I, Hollis I's son Hollis II, my grandfather, Hollis II's son Ansel, my father, and Ansel's son Octavius, me. No transfers, no partial sales, no carved-out parcels. The chain was clean. The chain had been clean for 186 years. The chain was on file in plain Brown County Recorder ink that any competent title examiner should have caught. The Hayland LLC title examiner had not caught it. The county building inspector had not caught it. The construction firm had not caught it. 5 different entities had failed to check the recorder's own database. Margot made screenshots of every record. She emailed them to herself, to me, to Caspian, to Vivienne, and to her own university research archive. The records were now in 5 separate places. The records could not, by any subsequent action, be erased. She picked up her phone. She called her stepbrother Caspian, my stepson, the environmental attorney in Bloomington, at 5 p.m. We had Caspian on speakerphone at 5:03. He listened for 14 minutes. He said, in the careful voice he uses with sensitive cases, "Dad, Margot, do not call the sheriff yet. Do not contact the developer. Do not tell the HOA. Do not post anything online. We need to do this the right way. I am driving down tomorrow. I will bring a colleague from my firm who handles property fraud. We are going to build a complete file before we move." I told him I would wait. I waited. Caspian arrived at 10 the next morning with a colleague, a 61-year-old senior partner at the Bloomington firm named Vivian Carrington, and a banker's box of legal research materials. Vivian Carrington had been practicing Indiana property law for 34 years. She was, in Caspian's careful description, the closest thing the Indiana property bar has to a single best authority on title fraud litigation. She walked the front hall. She read the 1838 patent. She read the 1962 attempted sale records I had pulled from my grandfather's archive. She read the construction permits. She sat at the kitchen table for 3 hours with Caspian and Margot and Phoebe and me. She made phone calls. She drafted a 1-page case strategy. She turned the page around at 1 p.m. She said, "Octavius, this is a clear case of constructive trespass with fraudulent title manufacture. The 1962 deed Halen Crossing Estates is relying on does not exist in the chain of title. We have pulled the Brown County Recorder's records this morning. There is no entry for a 1962 transfer of parcel 17-09-09-04-300 to any Knox Hayland or any Hayland LLC or any successor entity. The deed in their permit filings is a forged instrument that uses a real 1962 instrument number for an unrelated parcel in Monroe County. The forgery is sophisticated. The forgery has fooled the Brown County building inspector. The forgery has not been challenged because no one in the chain has bothered to compare the instrument number to the actual record. Octavius, you have a federal mail fraud case, a state title fraud case, a state criminal trespass case, an Indiana Department of Natural Resources floodplain violation case, and a clean civil ejectment under Indiana Code 3233. Plus, and this is the part I want you to understand carefully, you have a permitted dam at the upstream impoundment. The construction is downstream in the natural floodplain of your dam. The Indiana DNR maintains your dam under a permit that requires you to conduct periodic safety releases for impoundment health. The permit gives you wide authority to schedule and execute these releases. The releases, if conducted under permit, are not torts. They are not interference. They are not abatement of nuisance. They are routine dam safety operations that happen to occur in the natural watershed. Caspian said, "Dad, Auntie Vivian is telling you that if you release the dam under the existing DNR permit on a normal scheduled spring release, the water will go where the water has gone for 186 years. The water will run through the South Fork floodplain. The water will encounter approximately 100 residential frames that were built in the floodplain without permits, without proper title, and without any flood mitigation infrastructure whatsoever. The water will do to those frames exactly what 186 years of springtime runoff has always done in that valley. The water will be acting as water. The dam will be operating as a dam. You will be operating as the dam's permitted owner. The construction was illegal. The construction is in the wrong place. The water owes no apology to illegal construction in a natural floodplain." Phoebe sat for a long minute. She is the slowest, careful person I have ever loved. She said finally, "Tavi, open the gate. Do it correctly. Do it on the calendar. Do it with the DNR's written authorization in your hand. The water is going to clear the title." Phoebe and I sat at the kitchen table that night after Caspian and Vivian and Margot had left. Phoebe had not been raised in a family that owned hundreds of acres. She had been raised in Carmel, Indiana, by a school superintendent father and a stay-at-home mother who had taken her to the Indianapolis Museum of Art every other Saturday from age 4. She had become a curator because she had spent more weekends of her childhood in museum galleries than in her own backyard. She had married into the Brookmeer mill in 2012 with the careful patience of a curator stepping into a new collection, slowly, with handwritten labels, with no presumption of authority. By 2024, she had become, by every measure that mattered, the mill's co-steward. She had known the back 400 almost as well as I had known it. She had walked the floodplain with me 3 times a year since 2014. She had identified the place where Cornelius's original mill race emptied into Salt Creek's South Fork. She had named the small overlook where the floodplain widened into a meadow Margot had loved as a child. She had a curator's memory for landscape detail. She had a curator's care for what could not be replaced. She held my hand at the table. She said, "Tavi, you will do this the right way. You will let the water do what water has done in this watershed for thousands of years. The water knows. The water will sort this out." I told her I would. I called the Indiana Department of Natural Resources Division of Water on the morning of the 29th of April. I spoke with my regional dam safety inspector, a man named Wendell Stillwater. Wendell used his multiple names before, just a coincidence of Indiana regional surnames, who had been responsible for the Brookmeer Lake Dam since 2017. Wendell knew the dam well. He had inspected it annually for 7 years. He had told me, at the last annual inspection in October of 2023, that the dam was in excellent condition for its age, and that the spring 2024 routine safety release should be conducted no later than mid-May to manage spring snowmelt impoundment volume. The release had been on his calendar. The release had been on my calendar. The release had been scheduled, by mutual agreement, for the second Tuesday in May. I asked Wendell whether the release could be brought forward by 1 week. He asked me why. I told him, in the plain way the DNR likes to hear these things, that there was a downstream construction matter I would prefer to handle before the regular release date. He paused. He said, "Tavi, the DNR does not advise on title disputes. The DNR does advise on dam safety. From the dam safety standpoint, an earlier release is operationally fine. The earlier release is at your discretion under the permit. I will send you the written confirmation by close of business." I told him I appreciated it. He sent the written confirmation at 4:11 that afternoon. Across the weekend before the filings, Caspian and Vivienne built the file the way senior environmental attorneys build a federal file when the case is going to be national. Vivienne worked from a guest bedroom desk Phoebe had set up. Caspian worked from the kitchen table. They had 3 monitors going by Saturday afternoon. They pulled every Brown County permit issued to any Hayland entity since 2020. They pulled every corporate filing of every LLC associated with Lex Hayland. They pulled every wire transfer record reachable through subpoena-ready open records. They pulled the Indiana Department of Insurance records on the construction firm's bonding. They identified 2 co-conspirator entities, a Bloomington engineering firm that had signed off on the floodplain analysis without ever performing an actual site survey, and a Greenwood-based title insurance company that had issued title insurance on the parcel without performing a chain of title review. Both entities became co-defendants by the end of May. Both faced separate criminal exposure under Indiana statute. By Monday morning, the file ran to 640 pages, with 31 tabbed exhibits. By Monday afternoon, Vivienne had filed both complaints with the Brown County Court, and a separate civil federal mail fraud complaint in the U.S. District Court for the Southern District of Indiana. By Tuesday morning, the U.S. Attorney's Office in Indianapolis had opened a parallel federal investigation. By Wednesday, Indiana State Police Detective Halsey Lefebvre used in 2 prior scripts, just a coincidence of regional surnames, had been assigned as the state criminal lead. Caspian and Vivienne filed the federal complaint, the state complaint, and the formal title defense action with the Brown County Court on the 2nd of May. The Brown County judge, a 58-year-old Brown County native named Cordelia Trask, yes, the same name as a main judge in the propane case, just a coincidence of judicial surnames, issued a temporary restraining order on the 3rd of May, halting all construction at Hayland Crossing Estates, pending verification of title. The TRO was served on the developer Lex Hayland's office in Bloomington at 4:15 p.m. on the 3rd. Lex Hayland threw the TRO away. Construction continued through the weekend. Caspian filed for contempt on the morning of the 6th. Judge Trask scheduled the contempt hearing for the 11th of May. The The dam release was scheduled for the morning of the 7th. I want to be clear about one thing. I did not, at any point in this process, intend to harm any human being. The construction site was unoccupied. The site was an active construction zone with no occupied residences. The framed units were dry-in, but not finished. There was no plumbing. There was no power. There were no occupants. There were no animals. The site, by Indiana state construction labor law, was closed on Sundays and Mondays for off-season concrete cure schedules. The release was scheduled for 4:30 a.m. on a Tuesday, the first morning of the work week, before any construction crews arrived. I drove the site personally on the morning of the 6th at 5:30 p.m. to verify no occupants. I documented the inspection with time-stamped photographs filed under the DNR permit. The site was empty. The site had been empty for 48 hours when I returned at 4 a.m. on the 7th. The night before the release, Phoebe and I slept poorly. I was awake at 1 a.m. I made coffee. I sat at the kitchen table with Cornelius's 1839 mill journal, open to the gate installation entry. I read the entry twice. I closed the journal. I walked out to the porch and watched the dark across the pasture, toward the dam. The white oak gate had been waiting 185 years for the morning. I had been waiting 37 years to know what the gate would do. Phoebe came out at 3. She handed me a coat. She kissed my forehead. She said, "Tavi, the right thing is sometimes the loud thing. Cornelius would be glad." She walked back inside. I sat with the coffee until 3:40. I drove the gator out to the dam at 3:50. Wendell was already there. He had brought the field technicians. He had brought the paperwork. He had brought a thermos. The dawn was 25 minutes away. The water was waiting. Wendell Stillwater met me at the dam at 4:05 a.m. on the morning of the 7th. He had driven up from Bloomington in his DNR truck. He had brought 2 field technicians. He had brought the official paperwork. He had brought a thermos of black coffee. He stood at the wooden sluice gate with me in the soft pre-dawn light. He read the permit aloud, a formal DNR requirement for scheduled releases. He read each clause. He signed the inspection sheet at 4:23. He handed me the gate key. He stepped back. He said, "Octavius, you may proceed at 4:30 exactly. The release is authorized under DNR permit number 2017-Brown-014-Brookmeer. The water belongs to the watershed. The watershed belongs to the morning. Open the gate." I had practiced opening the gate 17 times across the previous 10 days. I had timed each practice. I had used the small handheld stopwatch I keep at the dam for routine maintenance logs. The fastest practice opening had been 78 seconds. The slowest had been 104. The average had been 91. I knew the gate. I knew the crank. I knew the resistance of the white oak against the iron at every point in the lift. I had not, before the morning of the 7th, ever opened the gate at 4:30 a.m. I had not, before the morning of the 7th, ever opened the gate with the knowledge that the water on the other side would do what the water was about to do. I gripped the crank handle. I looked up at the sky. The sky was the soft pre-dawn blue Indiana gets in early May. I thought about Cornelius. I thought about Aldina sewing the silver into her coat in Lancaster County in 1837. I thought about Hollis burning the Hayland offer in the wood stove in 1962. I thought about my father walking the fence line with me in 1980. I gripped the crank. I began to turn. I opened the gate at 4:30 and 17 seconds. The wooden sluice gate Cornelius Brookmeer had set in October of 1839 weighed approximately 700 pounds. The gate operated on a hand crank mechanism Cornelius had designed with a 4-to-1 mechanical advantage. I cranked the gate up to the fully open position across approximately 90 seconds. The gate came open with the slow groan of 185 years of well-maintained white oak working through cast iron. The first water hit the spillway race at 4:31 and 12 seconds. The first water hit the South Fork floodplain at 4:33. The first water hit the foundation slab of the easternmost completed frame at Hayland Crossing Estates at 4:36. I watched from the dam crest with Wendell beside me and the field technicians behind me. Phoebe sat in the passenger seat of my pickup, parked at the dam access road, watching from a distance with her hands folded in her lap. Margot and Caspian and Vivienne watched from the porch of the original 1839 farmhouse at a distance of half a mile. Nobody spoke. The release ran from 4:30 until 8:42 a.m. The lake dropped from a normal spring volume of approximately 3,000 acre-feet to a maintenance volume of approximately 1,200 acre-feet, a reduction of 1,800 acre-feet, or approximately 590 million gallons, over 4 hours and 12 minutes. The water moved through the South Fork at an average channel flow of approximately 38,000 cubic feet per second at peak release, slightly higher than the historical peak spring runoff in the same watershed by Wendell's later calculation, but well within the dam's permitted release authority and well within the natural channel's historic flow capacity. The water did what water does in a natural floodplain when a dam upstream releases its impoundment. The water spread laterally across the floodplain to a width of approximately 420 feet. The water rose to a peak depth of approximately 5 feet 10 inches at the deepest point. The water carried with it approximately 12,000 tons of upstream sediment and debris. The water encountered the Halen Crossing Estates construction site beginning at 4:36 and continuing through approximately 7 p.m. that evening. The water moved every frame structure that had been built directly in the floodplain channel. The water collapsed every slab-on-grade foundation that had been poured without proper flood elevation accommodation. The water lifted and floated and broke apart every quarter-finished house that had been built without permits in violation of Indiana floodplain code. By 8:42 a.m., when Wendell closed the sluice gate at the end of the scheduled release, the construction site at Halen Crossing Estates, Phase 1 was, by Wendell's documented inspection photographs, 93 frames collapsed or floated off their foundations. The remaining 7 were the 7 that had been built on the upper edge of the site, slightly above the natural floodplain, where the developer had hedged against possible runoff. Those 7 were undamaged. Those 7 would later be condemned by the Brown County Building Department for separate code violations and would be demolished at the developer's expense by the end of the year. By the end of that Tuesday morning, the Halen Crossing Estates Phase 1 construction was effectively destroyed. The total construction loss to the developer, by the insurance assessor's later filing, was $45.2 million. Nobody had been hurt. Nobody had been on site. The construction workers, who arrived at 6:30 a.m., had found the project underwater and called the developer. The developer had called his attorney. The attorney had called the police. The police had arrived at 7:15. They had spoken to Wendell at the dam. Wendell had shown them the DNR permit. The police had returned to the developer at 8 a.m. and told him that the dam release was a permitted DNR operation conducted by the property owner of record at parcel 17-09-04-300. The developer had then called Lex Haaland in Bloomington, who had then called his Bloomington attorney, who had then called Caspian, who had then advised Lex Haaland's attorney that any further communication should be routed through the Brown County Court, where the federal and state title fraud complaints had been filed 5 days earlier. Lex Haaland was arrested at his Bloomington office at 3:30 that afternoon on Indiana state charges of fraudulent conveyance, forgery of public instruments, criminal trespass, and conspiracy. Federal mail fraud charges followed 3 weeks later. He had 2 business partners. They were arrested the same week. The Bloomington Construction Company that had executed the construction work was indicted in June for negligent construction and operating without valid title authorization. The county building inspector who had approved the original permits was placed on administrative leave, pending the audit of his permit approval practices. The audit found that the inspector had received approximately $78,000 in unreported consulting fees from the Haaland LLC over 30 months. He was indicted in August. Tabitha Ashland Cromwell, the HOA board president of the still phantom Halen Crossing Estates, was indicted in late June. She had been Lex Haaland's cousin. She had been hired by him in 2022 to run the marketing and community management for the development before it was sold. She had been paid $116,000 across 2 years. She had known about the title issues. She had received an emailed warning from a Bloomington title attorney in early 2023 that the chain of title had irregularities requiring further review. She had told the attorney to find a way to make it work. The email had been recovered by the Indiana Attorney General's investigators in late May. She took a state plea in November. 18 months Indiana state custody, 3 years probation, restitution to the various legitimate buyers who had put earnest money on Phase 1 units, a permanent ban from serving on any Indiana community board. Lex Halen took a federal plea in February. 41 months federal custody, 5 years federal probation, $12 million in restitution to the legitimate buyer investors who had put earnest money down. He reported to federal custody in March. He has not made a public statement. In the days between the release and the August court order, the story moved through Brown County and southern Indiana in the slow, careful way these stories move when the local press is small but attentive. The Brown County Democrat, a weekly newspaper founded in 1885, ran a front-page feature in its 16th of May issue. The headline read, "The Gate That Remembered 1838." The article was written by a 40-year-old Brown County historian named Sefton Hadley, who had taken 3 of my industrial history seminars at Bloomington in the late 2000s. Sefton interviewed me for an hour on my back porch on the 10th of May. He interviewed Phoebe for 40 minutes. He interviewed Wendell Stillwater. He interviewed Magnolia Beachfield at the recorder's office. He did not interview Tabitha Ashland Cromwell or Lex Halen, who had retained Bloomington Defense Counsel and were under court-ordered silence. The article ran 2,000 words. The article ended with a quotation from Cornelius Brookmeyer's 1839 Mill Journal that Sefton had located in my archive. "Built the gate today with the white oak. The gate will outlive every man here. The water knows where it goes." The journal entry is dated the 22nd of October, 1839. The journal is in the front hall case beside the patent. Sefton's article hangs framed in the mill office between the DNR certificate and the conservation easement. The back 400 acres were quit-claimed back to the unambiguous Brookmeer family ownership by Brown County court order on the 18th of August. Phoebe and I walked the floodplain together on the morning of the 19th. The water had subsided. The sediment had settled. The collapsed frames had been removed by court-ordered debris contractor crews across the previous 10 weeks. The land looked as it had looked in 2003, the year I had last walked the floodplain after the spring snowmelt. Salt Creek's South Fork ran clean. The hardwood trees on the upper benches were undamaged. The natural channel of the floodplain was restored to its pre-construction state. The Indiana DNR conducted a follow-up assessment in September. The assessment found the floodplain biologically and hydrologically restored to historical condition. The DNR sent us a small certificate of restoration. The certificate hangs in the mill office. The legitimate buyer investors, 63 families who had put earnest money down on Halen Crossing Estates units between 2022 and early 2024, were eventually made whole through the federal restitution order and through the bankruptcy proceedings against the developer. The average earnest money refund per family was $31,500. The total recovery to the families was just over $2 million. The recovery process took 18 months. The Brown County Bar Association established a small pro bono program to help the families navigate the federal claims. Vivian Carrington led the program out of her firm. Caspian volunteered 800 hours of unpaid time across the 18 months. By the end of the recovery period, every family had been compensated. 11 of the families had subsequently bought into a different and legitimate Brown County development called Salt Creek Ridge Estates, built on land actually owned by the developer, with all permits in proper order. The remaining 52 families had used the recovery to buy or rent legitimately elsewhere across central Indiana. No family had lost its life savings. No family had been left homeless. The careful restitution work mattered to me almost as much as the title recovery. Most of the families had been deceived in good faith by the same fraudulent paperwork that had deceived the building inspector. None of them deserved to lose their homes for Lex Halen's choices. We placed a permanent conservation easement on the back 400 acres in November. The easement is held by Sycamore Land Trust of Bloomington. The easement permanently protects the back 400 from any future development, construction, or floodplain modification. The easement covers the entirety of the historical floodplain Cornelius Brookmeyer had walked in 1838. Caspian drafted the easement. Vivian Carrington reviewed it. Phoebe and Margot co-signed it with me. The easement, when recorded with the Brown County Recorder, was filed under instrument number 2024-1838, a number Caspian had specifically requested from the recorder as a small tribute. The recorder, an 80-year-old Brown County native named Magnolia Beachfield, had laughed once and told Caspian she had been waiting 40 years for somebody to ask for a vintage filing number. She made it happen. Bertram Crow, the Brown County millwright who had helped me restore the water wheel across the summers of 1991 through 1996, passed in his sleep at age 83 in March of 2025. His funeral was held at the Brown County Methodist Church in Nashville, Indiana. 210 people attended. I gave a 4-minute eulogy. I told the room about the spring equinox of 1997, when the wheel had turned for the first time in 69 years, and Bertram had cried quietly at the dam crest. Bertram's widow Cornelia, yes, the same first name as Judge Trask and Cornelius Brookmeer, a Brown County coincidence Bertram had laughed about for 40 years, gave me a small wooden box at the reception after the service. Inside the box was Bertram's millwright's wrench he had carried with him on every job since 1962. The wrench was inscribed on its handle with the simple phrase, "B. Crow, 1962. Cornelia said, "Octavius, Bertram said the wrench should come to you. He said you would know what to do with it. I have hung the wrench in the mill office above my desk. It hangs above the certificate of restoration. It hangs above the conservation easement. It hangs in the line of objects that mark how the work of careful people accumulates across generations." The mill is open to the public on Saturdays from May through October. Brown County school groups visit on Tuesdays during the school year. The interpretive program, which Phoebe runs now in addition to her summer continuing education seminar at Bloomington, covers the 1838 federal land patent, the 1839 mill construction, the 1962 attempted sale and refusal, the 2024 title fraud case, and the morning of the 7th of May. Children visiting the mill stand at the open sluice gate. Phoebe tells them, in her quiet curator voice, Cornelius Brookmeer set this gate in October of 1839. Octavius Brookmeer opened it on the 7th of May, 2024. The same gate, the same lumber, the same crank. Some pieces of land remember their owners. This land remembered Mr. Brookmeer on the morning of the 7th of May. The children listen. The children ask questions. The children, by my running count, have asked 16 times in 2 years whether they can see the gate themselves. Phoebe lets them touch the white oak. The lumber is, by my last carbon dating estimate, 241 years old in the inside of the grain rings. The lumber has held up better than any of the construction Lex Halen tried to put downstream of it. Margot's daughter, my first grandchild, was born on the 17th of March in Indianapolis. Margot named her Aldina Wren Brookmeer, after my great-great-grandmother, who had sewn the silver coins into her coat in 1837, and after Margot's own mother, who had passed in 2007. Aldina Wren weighed 7 pounds and 4 ounces. Margot brought her down to the mill for her first visit the second weekend of April, when she was 3 weeks old. Phoebe held her at the kitchen table. Margot laid the 1838 federal patent open on the table next to the baby. She said, "Aldina, baby, this is the paper Cornelius signed in 1838. Cornelius is your great-great-great-great-grandfather. The 1838 ink and the 2024 ink in the conservation easement are the same color. Your mother filed both of them." Phoebe cried. I cried. Margot did not cry. She had become, in the months of pregnancy and the months of legal work running in parallel, a different kind of careful person. She held the baby the way her great-great-great-great-grandmother had probably held her own first child in October of 1838, 6 months after the patent issued. The line ran clean. The line was going to run cleaner. I sit on the front porch in the evenings now with a cup of coffee and the family Labrador Magnolia at my feet. Yes, the same name as the county recorder. Phoebe had picked the name when we adopted Magnolia 3 years ago because the recorder had been kind to us during the title fight. And I watched the old 1839 farmhouse settle into the evening. The mill office has the small Indiana DNR certificate of restoration framed on the wall behind my desk. The 1838 federal land patent hangs in the front hall in its climate-controlled case. The 2024 conservation easement, instrument number 2024-1838, hangs above my desk in the mill office. The wooden sluice gate sits at the dam, closed since the 7th of May, waiting for the next scheduled DNR safety release on the 11th of May next year. The water belongs to the watershed. The watershed belongs to the family. The family is 5th generation. going on 6th. Margot is expecting her second child in May of next year. The first, Aldina Wren, is 15 months now. She has begun to walk. She has begun, by Margot's last weekend report, to recognize the word mill when Margot uses it at the dinner table. Phoebe and I drove up to West Lafayette in June to spend a Saturday with Margot and Aldina. The baby took her first hesitant steps across the kitchen toward me. I had not been ready to cry. I cried anyway. Phoebe took a photograph. The photograph hangs in the front hall next to the patent. The photograph and the patent are now, by my own quiet reckoning, the two most important documents on the property. The patent is the legal foundation of 187 years of Brookmeer stewardship. The photograph is the visible promise of 187 more. Aldina Wren will be old enough to read the patent herself in another 7 or 8 years. I plan to be alive when she does. Phoebe plans to be alive when she does. We have, between us, exactly enough years to teach the next steward what the old steward knew. That is the math. That is the work. That is the way the line continues. Cornelius left a journal entry from the spring of 1842 that I have carried in my head since I first read it at age 26. The land does not belong to us. We belong to it. The work is to know which way the water goes. The journal is in the front hall case. The page is open to the entry every Saturday for visitors to read. I had not, until the morning of the 7th of May, fully understood what Cornelius had meant. I understood now. The water had gone exactly where the water had gone for 186 years. The water had cleared the title. The water had not asked permission of anyone. The water had not been angry. The water had simply been water, doing in 2024 what water had been doing in 1838. In the same valley, between the same limestone shoulders. At the same hour, Cornelius's wife, Aldina, would have been kindling the morning fire in the original 1839 farmhouse. Some pieces of land remember their owners. Brookmeer Lake had remembered me on the morning of the 7th of May. It will remember Aldina Wren when her turn comes. That is the line I have to leave her. If you have ever had a Karen build something she did not own on land that did not belong to her, leave a comment below. Tell me what she tried. Tell me what you did back. I read every one. The stories you send me are the reason I keep telling these. If this one warmed you, hit subscribe so the next one finds you. Next week, we've got a single mother in rural Indiana whose HOA Karen tried to tear down her son's swing set. There is a wedding video that Karen did not know was running. That story is coming Friday. In the meantime, read your patent. Walk your back 40. The 1838 ink does not fade, and the sluice gate does not lie. Wendell Stillwater retired from the Indiana DNR in November of the following year. His retirement party at the Brown County 4-H Fairgrounds drew 240 attendees from DNR offices across central and southern Indiana. I gave a 6-minute toast. I told the room about the morning of the 7th of May, 2024. I told them about the White Oak Gate. I told them about the moment Wendell had handed me the gate key at 4:23 a.m. and said, in his careful Indiana DNR voice, "The water belongs to the watershed. The watershed belongs to the morning. Open the gate." The room applauded. Wendell wiped his eyes. He took the job of part-time consulting hydrologist for the Sycamore Land Trust in January. He still answers his phone when I call. He still inspects Brookmeer Lake every spring as a personal courtesy. The next scheduled DNR safety release is set for the 11th of May next year at 4:30 a.m. Wendell has been on my calendar for it for 14 months. I will be ready. That is the story of Brookmeer Lake.
First, this one was about an Indian industrial historian who knew his own land like a man knew his own grandfather. The bitter ashland Cromwells did not lose because Octavia Brookmeer was a minor landowner. She lost because she had been running a developer's title fraud scheme on a man who had spent 37 years cataloging every square inch of his family's 850 acres. The lesson, friends, is that the Lord sometimes lets the historian. The 1838 land grant Tavy pulled out of his archive on the morning of the federal court hearing was the document that ended the case. Some old paper outlets new mortgages. If you have ever had a Karen build something they did not own on land that did not belong to her, leave a comment below and tell me your story. I read everyone. They remind me we are not alone. He's surprised, so the next one finds you. Next week, a single mother, a swing set, and a wedding video coming Friday.